Okay, good morning, and welcome back to the Rhine Report, where we have breaking legal news and an important update on Oregon versus Trump and the Judge Immergut orders granting injunctions to the state of Oregon, refusing to allow Trump to deploy his military, in this case, National Guardsmen, into the cities of Oregon. In what is the most important legal set of cases ever brought to date, aside from Ex parte Milligan and Ex parte Merriman, along with a sister case in California against the Trump regime's arrogant, brazen, and wholly unconstitutional attempt to militarize our cities using false claims and lies to rationalize, not justify, rationalize the use of federalized National Guard and military in a manner more in common with a totalitarian regime than within a functioning democracy. In my previous posts, I broke down the laws that are involved here and that remain relevant to the issues in front of the Court of Appeals, Ninth Circuit Court of Appeals, hearing the possibility of a stay of the injunctions issued by Judge Immergut. Those posts are: federal judge refuses to issue a TRO, that's one, and the other being Trump threatens the Insurrection Act and martial law. So, today, on October 9th, 2025, the Ninth Circuit Court of Appeals is holding a hearing concerning a lower court's restraining order against the deployment of the Oregon National Guard. The restraining order was issued by U.S. District Judge Karen Immergut and blocked President Trump's attempt to federalize and deploy the Guard, in which an administration stay has already been issued. A three-judge panel of the Ninth Circuit issued a temporary administrative stay on Wednesday, the 8th, that pauses Judge Immergut's order. However, this stay only pertains to the federalization of the troops, which they've allowed, but not their deployment, which they have not allowed. So they cannot be deployed as yet. But unfortunately, two of the judges are Trump appointees. Now, the temporary stay puts Immergut's first order on hold, allowing President Trump to, as I said, federalize the Oregon National Guard. The judges wrote that this preserves the status quo, although I don't see how it does. The status quo should be that they've not been federalized. However, there we are. So aside from federalization being preserved, which it shouldn't be, deployment is still blocked, thank God. The administrative stay does not lift Immergut's second order, which continues to bar the president from deploying the troops. Small favors here. So here are the details of today's hearing. The Ninth Circuit panel is going to hear arguments today on whether or not to extend the pause on Immergut's order while it considers the broader appeal. What's at stake? The hearing will address whether the president has the authority to federalize and deploy the Guard against the governor's objections. What is the controlling law? The court is considering whether the situation in Portland, which Immergut called not significantly violent or disruptive enough, meets the legal requirements for presidential deployment under federal law. And the law is, again, 10 U.S.C. 12406, which I've discussed and explained ad nauseum in my previous posts. So, watch out for this angle. Judicial deference. A legal concept. It's not law. It's going to come into focus and play a role once more, as in the Judge Breyer case heard by the Ninth Circuit 3-judge panel of Newsom versus Trump. And bear in mind Judge Immergut's conclusion that the president's claims, even allowing for judicial deference, are completely untethered to the facts on the ground. Finally, it should be noted that 20 states have already submitted amicus briefs in support of Trump, and, coincidentally, 20 states have submitted briefs in support of Oregon and Immergut's order to block troop deployments. This is where our country is right now. Talk to you later as updates occur. Take care.